The European Court of Human Rights is considered one of the most important human rights courts in the world, and Ireland was a founder member. Welcome to the podcast series, The European Court of Human Rights, an Irish perspective. In this third and final episode, we explore the question, what has been the influence of the Convention and the European Court of Human Rights on the island of Ireland? Mr. Justice Brian Murray of the Supreme Court.
I'm going to begin by reflecting on more than 75 years of the Convention and what I see as being its most significant influence on Ireland. And I'm going to do that from a legal perspective. In that regard, I think it's important to stress that the Convention's significance within our law is not just at the level of particular cases or particular rights, nor indeed in prompting specific legislative changes as it did in relation to civil legal aid. It's also had an important and broader impact on the plane of constitutional analysis and methodology, and indeed what I would categorise as, for the want of a better term, legal culture. John McMenamin said in one of his judgments that there are occasions on which an external critique can be useful in creating an insight into the way in which our own legal system is perceived. That's right. That's one of the effects of the European Convention, and it has inevitably prompted positive reflection on how exactly we frame and justify our own constitutional analysis.
The Convention was incorporated into Irish law through the European Convention on Human Rights Act 2003.
That legislation effected a change in the relationship between the Irish courts and the European Court of Human Rights, but in a measured manner. It did not make Strasbourg a superior domestic court. What it did change was to make the relationship more structured and more frequently invoked. After 2003, the Convention's jurisprudence moved from the margins of argument into the ordinary day-to-day business of the courts. But Irish case law has also been careful about the limits of that relationship. That's why the relationship is best to be described as one of engagement, respect and dialogue rather than hierarchy. The Supreme Court has regard to the Convention. It takes account of the decisions of the Strasbourg Court in its own constitutional analysis, but it cannot surrender the autonomy of the Constitution, and in the event of unavoidable conflict, the Constitution must prevail. The rule is one of consideration, but not subordination.
In the United Kingdom, the Human Rights Act 1998 incorporated into domestic British law the rights set out in the European Convention on Human Rights. Lady Chief Justice of Northern Ireland, Siobhan Keegan.
And this was extremely important because what it did was it made the European Convention on Human Rights part of domestic law. That has necessarily brought about a lot of jurisprudence before our courts. The Human Rights Act, in very brief summary, requires courts to look at law through the prism of the Convention, to try and interpret law in a Convention-compliant way. And it also gives courts the power to issue declarations of incompatibility if the court considers legislation does not comply with human rights. The point about the Human Rights Act is that it retains the issue of parliamentary sovereignty at its core, in that if you make a declaration of incompatibility, the UK Parliament must act on it, but the law remains as is. And most of the time, the law will change and will develop. Therefore, this relationship between the UK Parliament and the European Court of Human Rights is complementary and preserved.
Perhaps the clearest influence of the European Court of Human Rights on the island of Ireland can be traced through the cases heard before the court.
While some of the very important cases decided by the Court of Human Rights against Ireland were followed by very significant changes to the law here, it's perhaps a question for others whether those changes would have occurred anyway, and if they would have occurred anyway, when that would have happened. But there is no doubt in my mind, but that at the very least, the Convention has provided both an impetus and in some cases a justification for changes that legislators might not otherwise have viewed as matters of priority.
The ECHR empowers the individual and the individual lawyer actually to think of remedy in a fundamentally different way.
Fionnuala Ní Éileán, Professor of Law, School of Law, Queen's University, Belfast.
Remedy doesn't exist just within the national understanding of remedy, but it's something I've always said to my students, you have to sort of shift your mind and shift your lawyering to understand that you have this set of remedies that exists beyond the national. And both the kind of legal power of that, but the imaginative power of that, I think is extraordinary for lawyers, but also it sort of changes the oeuvre of a legal system. It reshapes what you think is possible. So I think that's one really important thing.
We can also consider how the court's case law is accessed. How have 75 years of judgments and legal knowledge been shared? Anna Austin, jurisconsult at the European Court of Human Rights.
The court has realised this a long time ago, that we need to communicate in many respects, but notably on our case law, to make sure that that case law is, well, first of all, is accessible. Secondly, is understood and notably not misunderstood or misrepresented. One needs to recall perhaps the unique functioning of the European Court of Human Rights. That's a court that sees tens of thousands of cases every year. I think it's been a while since we've decided the millionth case before the court. The jurisconsult does, conceptually speaking, is that it manages knowledge. And we have developed a variety of very particular tools to provide case law analysis to judges and lawyers when and where it's needed. And for me, the more modern, the more effective, and frankly, one that has revolutionized the way we have access to our own case law is the knowledge sharing platform. And what that does in simple terms is to provide comprehensive, up-to-date case law analysis on all our chamber and grand chamber case law.
Well, the Grand Chamber at the European Court of Human Rights is the superior formation of judgment inside the court.
John Darcy, Deputy to the Registrar, Grand Chamber of the European Court of Human Rights.
And it brings together the senior members of the court, that is to say the President, and the judges who have been elected to preside over the 5 sections of the court. And they are joined by judges who are drawn by lot, making a formation of 17. It is the formation which deals with the most significant and important cases that come to the European Court of Human Rights. So the Grand Chamber represents the highest level of judicial authority of the court. Its judgments are generally landmark judgments. They set the framework of interpretation for the court and beyond the court for all national courts that are also following and applying the Convention.
So if you want to know anything about the Convention case law, you simply click on the knowledge sharing platform from the court's internet site, and you have there access to this world of Convention analysis, subject by subject, article by article, everything you wanted to know about the Convention case law, up to date till last week, is there for anyone who wants to access it.
In our previous episodes, when we explored Ireland's influence on the European Court of Human Rights, we explored the Lawless versus Ireland case of 1960 and the 1976 Ireland versus UK case. These cases, in turn, also had a profound influence on Ireland itself.
Yeah, so, I start with Lawless and I say, well, Lawless is the influence of empowerment. The ECHR empowers the individual and the individual lawyer, actually, to think of remedy in a fundamentally different way. Second influence is the Ireland-UK case. I think that case is enormously psychologically important for Ireland, both legally and politically, and to Irish legal culture. Why? Because I do strongly believe as a post-colonial society, we are shaped and defined by a set of historical baggages about being the colony. So that idea that you could use the law, that the law was a tool for a small state to validate its legal values, I think is really important. And the cases I've talked about have to do with security and autonomy and sovereignty in a way. The other line of cases, of course, are cases around individual autonomy and individual sovereignty and the influence of the ECHR on sort of matching the sovereignty that Ireland was seeking to have in its external relationships with the sovereignty of the body in Ireland, and in particular women's bodies,
Síofáil O'Leary put it very well a few years ago when she said that in many cases, not just cases against Ireland, The European Court of Human Rights has sought to remedy blind spots within national systems, which might have been difficult for national judges, and I would add legislators, to identify or remedy themselves, given that their roots are to be found in national, cultural, social, or religious heritage. For my part, I think the Convention has, at the very least, accelerated the development of civil legal aid and of the imperative to provide remedies for delays within our legal system. It's been of importance to the Irish courts as we grappled with rights within the criminal process, as in our cases dealing with the privilege against self-incrimination, or rights of legal representation at early stages of that process, in all of which reference was made to the ECHR jurisprudence. But it has also encouraged the acceptance that the moral disapproval of the majority is not in itself a determinative basis for impairing constitutional rights. I think the decisions in Erie, Norris, Open Door and ABC are the Irish cases that merit closest attention in terms of their impact. In Erie, the court said that access to justice must be practical and effective rather than merely theoretical and illusory. The consequent obligation to provide legal aid in connection with at least some types of family law proceedings directly precipitated the establishment of the civil legal aid scheme here, the non-statutory precursor to the establishment by statute of the Legal Aid Board. That, of course, changed the functioning of our legal system in the context of family law and later other areas as well, significantly.
Erie's a really good example. You think of, again, a really brave person, Joanne Erie, who's in the middle of proceedings, has no legal aid. And so this right to be separated under Irish law, which was so constrained, obviously we didn't have a right to divorce her. You could, of course, seek an annulment, but the limitations on women's rights of access to separation from a spouse in real terms were enormous because the barrier was always financial. And so through the procedure of the right to legal aid, you're actually able to exercise this autonomous right to be separated from a person to whom you've been married under law. And so I think that's always been one of the hallmarks of the ECHR's jurisprudence, is that we often get the access to fundamental rights through these highly procedural cases. The court has often used procedure as a way to get at substance, and it's been a stealth policy that has served the court well, because as a lawyer and as a professor, I always think that and say these stealth moves are often much more effective in the long run than the kind of full-on sort of assault on a particular absence of a right. So I think these cases were important, but they speak to something else, which is, why did we need these cases? We needed these cases because, frankly, in my own view, it's really important to acknowledge the court is doing this work and influencing in because there's a gap at home. We're failing to do some things that our courts are failing, our legislatures are failing. And so I think those cases laid the groundwork.
Wellwoman and Open Door brought the court into the white heat of a highly divisive legal and social controversy. There, the matter came before the Court of Human Rights because the Irish courts had granted injunctions against two companies providing various health and advisory services to women, precluding them from assisting women to travel abroad to obtain abortions, including by informing them of the identity and location of clinics or how to contact them. The orders were made in 1988, when the understanding was that the effect of the Eighth Amendment to the Constitution had been to impose an absolute ban on all forms of abortion in the state. The claim was brought to Strasbourg in 1988, based largely on the guarantee of free expression in Article 10 of the Convention. It came for oral hearing before the court there on March the 24th, 1992. But only 2.5 weeks before that, the Supreme Court had delivered its judgment in the Attorney General and X, the effect of which was that the termination of pregnancy was permissible when there was a real and substantial risk to the life of the mother if there was not a termination. That created an obvious issue around how there could be an absolute prohibition on assistance of the kind reflected in the order of the Supreme Court made against Wellwoman and Open Door. How could it be unlawful to provide information to those seeking to avail of a medical service when the service itself was available in certain circumstances lawfully? During the oral hearing before the Court of Human Rights, counsel for the government made a statement acknowledging, in the light of the decision in X, that women entitled to a termination in the circumstances described in the X case were entitled to access to information regarding those services. That concession, the Court of Human Rights said, showed in itself that the court orders were excessively broad. But in finding the restrictions disproportionate, the court also stressed that much information as to the availability of termination services was accessible lawfully in other ways, such as through magazines and telephone directories, that the ban had not been effective in preventing women from travelling abroad to avail of those services, and that the link between the provision of information and the destruction of unborn life, the asserted basis for the measure, was not, as it said, definite. The decision of the court was delivered in October, and less than a month later, constitutional amendments guaranteed freedom of travel and information were put to the people. They'd been under consideration since the X case itself. In practical terms, the decision is one important step in the narrative that led to the eventual repeal of the Eighth Amendment. But outside the specific arena of termination of pregnancy, many found the Irish court's issuing of the injunctions in those cases to represent a blunt and unfocused constraint on free expression. The European Court of Human Rights decision underscored the need for a more robust analysis of the justifications for constraints on expression than had been adopted in the domestic courts. The decision of the court in ABC was delivered in December 2010. This is a highly nuanced judgment in which the court in 2 of the 3 cases presented to it arising from Ireland's then abortion laws found that the prohibition on abortion was not a violation of Article 8 of the Convention. However, in the case of the third named applicant, whose case was that she had a right under Irish law to abortion services because of the impact on her health of her pregnancy, it was found that the lack of legislative implementation of Article 43.3 and by the lack of effective and accessible procedures to establish a right to an abortion, the state had failed to comply with its positive obligation to secure respect for private life. The failure to legislate and the failure to clearly regulate the rights that the Supreme Court itself had identified, thus was found to impede their accessibility.
It's the power of law. You know, we can get super cynical about law. We can be very cynical about international law right now. I think it's very difficult. As a teacher of international law, I see my students saying, what's it good for? They're watching the lack of capacity to prevent massive violence against civilians in places like Lebanon and Gaza. And they're saying, like, what's it good for? I would go to Norris. Norris was 1988.
Norris, which in truth followed closely after the decision in Dudgeon, finding the same legal provisions as applied in the north of Ireland, criminalising consensual homosexual relations between adults, to be contrary to the Convention. It involved the European Court reaching a conclusion directly contrary to that arrived at by a majority of the Supreme Court applying domestic constitutional provisions. The decision was an emphatic affirmation of classic liberal principle and, of course, was followed by decriminalisation in June 1993.
I think the bravery of Norris, like, we forget behind all of these cases is often a very brave person and a very brave lawyer. The risk people take to put themselves out as the front of a legal argument when socially and politically society is not in the same place as that. Like, for LGBTQI plus persons, they don't have equality under law in Ireland at this time. And this case just smashes that. You know, that case was just such a powerful case. It was such an articulation of sexuality as a right, that we have a right to this, that sexual rights are an inherent part of human dignity, and that people have a right to love whom they love. Now, it's not, of course, that's not the language the court used. It's far more constrained than that, but that's the imaginative power of this case.
The common thread to these cases is that they place issues of privacy, sexual identity, reproductive decision-making and intimate relations in a legal context in which, whether by reference to bodily integrity, privacy, dignity or personal autonomy, incursions by the state into those zones demands both legal certainty, the key feature of the decision in A, B and C, and justification. That justification being framed within a proportionality test. That means that issues that might in different contexts have been viewed as simply matters of public morality or of social norms fell to be analysed in a more critical way.
We can also reflect on the influence of the European Court of Human Rights on the jurisprudence and legal principles in Northern Ireland. Lady Chief Justice of Northern Ireland.
In terms of jurisprudence dealing with the Convention articles, Article 2, which is the right to life, has generated a lot of cases from Northern Ireland heard domestically and in the European Court of Human Rights. And these are very important cases. They're related to our troubles. And most of the cases, particularly the most recent cases, are really about what's called the procedural aspect of Article 2, which in a nutshell is the state's obligation to investigate deaths that have occurred during the Troubles. The cases are really important in this area in relation to Article 2 because it's an absolute right. And you can imagine that this captures the attention of many people living here because of many Troubles cases that are unresolved.
I think over the time, the European Convention has become perhaps the key functioning safeguard in Northern Ireland in relation to providing a form of remedy for human rights violations.
Daniel Holder, Director of the Committee for the Administration of Justice, CAJ.
It's worth reflecting, actually, sometimes you'd hear politicians on the broadcast media openly using language like families deserve an Article 2 compliant investigation without the journalist feeling the need to ask them to explain what that means, in the sense that the language of the procedural obligations under the European Convention of Human Rights, which most people wouldn't be familiar with, is quite embedded in the Northern Ireland context because we speak so much, particularly in terms of legacy cases.
One legacy case carries particular significance. The case was regarding Mairead Farrell, Daniel McCann and Sean Savage, who were shot dead while unarmed by the SAS in Gibraltar in 1988.
This is a very controversial case. 3 members of the IRA who were travelling to Gibraltar, one of whom was a student. I was a student at Queen's at the time, and Mairead Farrell was also a student at Queen's at the time in the politics department. And they were shot dead, simultaneously shot by members of the SAS, an elite regiment of the British Army. And again, a very, very brave lawyer, PJ McRory in Belfast, took that case against the advice of everyone, who said, how are you going to defend the right to life of 3 people, 3 terrorists who have gone to Gibraltar to do ill? Why would that be the case you would take to define the right to life under the European Convention on Human Rights? And of course, as we know, that case went on to the Grand Chamber, the chair deciding that there had been a breach of the right to life, because it was very clear that there had been no attempt whatsoever to arrest these 3 individuals, that it had been a process that ultimately was designed to bring around death rather than to bring 3 individuals who rightly could have been charged with a whole range of offences under law. And that case and so many other cases that are really now what we call the legacy cases, these were the cases that set out a set of principles around which any rights-bearing settlement would have to be addressed, where rights, accountability, the rights of victims, the right to legal process, to know what happened to somebody you loved if they had been killed during the conflict, that those were all principles established through the European Court on Human Rights. And one of the things I would say living in Northern Ireland that always struck me is that there were many, many, many more cases going from Northern Ireland to the ECHR than there were in the South for a long, long time. The bar and lawyers, and I've been a member of CAJ, a human rights organisation in Belfast, for almost 30 years. And we were all taking or involved in these cases. And we knew that it was going to shape the post-conflict landscape, that it was going to help us shape a set of claims. And the authority of the convention brought home to the negotiation, shaped the negotiation. And it absolutely did.
The whole way that the legacy architecture, the mechanisms that investigated cases after the Good Friday Agreement, what's called the package of measures that the UK government adopted, it's often forgotten that that was adopted as the direct result of cases that were taken in the late 1990s and the early 2000s directly to the European Court of Human Rights. So you had a whole raft of cases where families took cases to the European Court of Human Rights directly, alleging that the UK, in cases where members of the security forces had been directly responsible for killings, or whereby there was suspected collusions in killings, alleging that there had not been a proper and independent investigation into the killing. And those cases were all won. The court decided that the UK was in breach of the convention for not having any sort of mechanism within its ordinary justice system that could properly investigate state killings or collusion killings. The UK was then obliged to adopt a package of measures, which included things like changes to the inquest system so it could investigate conflict-related deaths, the role of the police ombudsman in legacy investigations, a number of public inquiries, the establishment of, firstly, a historical inquiries team, then a legacy investigations branch within the police service. So the whole legacy architecture was put into place as a result of cases taken under the ECHR to the European Court of Human Rights. That had a huge impact in Northern Ireland.
The particular issue in Northern Ireland that I think is worth mentioning is that our peace settlement is prefaced on the convention, and that's actually in the preamble to the convention. It's central that the peace settlement, which found articulation in the Good Friday Belfast Agreement and then the Northern Ireland Act, sought to achieve reconciliation, tolerance, mutual trust, and the protection and vindication of the human rights of all. So that's a very strong statement, which I think it's fair to say frames both our constitution here and our law.
And that's made a very significant difference across a whole range of spheres. So there is the example, of course, of legacy cases. The architecture was set up by cases taken directly to the European Court of Human Rights. The legacy mechanisms faced a lot of state obstruction. What was Families' remedy to that? Families' remedies were to go to court and challenge because they had not met the requirement of the European Convention of Human Rights. And they could do that in the domestic courts, in the reformed justice system within Northern Ireland, precisely because the Good Friday Agreement required legislation to incorporate the European Convention of Human Rights. But it doesn't stop with issues around remedies for past violations. I think we really should reflect on how the European Convention on Human Rights really has been the framework for what's been the relatively successful reforms to policing and justice in Northern Ireland as a consequence of the Good Friday Agreement. If you look at the reforms to the PSNI, for example, PSNI has a binding code of ethics that officers cannot breach, and if they do, it's misconduct, it's actionable to the Police Ombudsman's Office. That code of ethics is largely based around ECHR standards, as well as some other sort of soft law standards. But at the core of it, it's the ECHR. It's also led to a circumstance where some of the abusive legislation of the past that fueled conflict simply cannot be implemented in a way that it was. If you take things like the restrictions on freedom of assembly, or you take things like even issues around flags and displays in public space, this is actually quite a recent example. Earlier in 2026, the PSNI, Police Service of Northern Ireland, adopted a new policy, a new service instruction on how to deal with harmful public displays that would maybe have a content that reached a criminal threshold. A lot of that is to do with questions around the use of flags. What they've taken in this new policy is very much a human rights-based approach, i.e. that, yes, there's a right to freedom of expression, but there are boundaries to that, and a duty on public authorities to take reasonable steps to prevent racist expression and racist intimidation. And obviously racist in the Northern Ireland context would include that very specific form of racism that is sectarianism. I suppose that's what we always should be cognizant of with the convention. There are bits of it which are things that states shouldn't do and public authorities shouldn't do, like torture people. These are negative obligations. But equally, there's positive obligations about things that states must have in place. So there must be something to combat racist intimidation. And equally, there must be some sort of functioning justice system to ensure effective investigations into deaths, including where there's potential state involvement. Given the framework of the ECHR, we're in a very, very different place with that now. We now have policy frameworks that really are grounded in rights holders to be, in the words of the Good Friday Agreement, free from sectarian intimidation, and also that stood us well in dealing with many of the issues that have arisen with the rise of the far right in the north. The ECHR, in reality, has been the key safeguard of the Good Friday Agreement. It's been the safeguard that has really shaped the transformation towards human rights compliant policing, and it is accessible to victims through the Northern Ireland courts. That's what the Good Friday Agreement requires. And if there was any change to the UK's position on the ECHR, it would not only damage all those rights frameworks, but would fundamentally breach the obligations under the Good Friday Agreement.
I would say one of the single largest existential threats to the sanctity of that treaty is the potential that the UK will withdraw from the ECHR and pull out that fundamental foundational piece from the compact that was made under the Good Friday Peace Agreement. So, yeah, enormously important to the North and hugely important going forward to maintain our peace agreement. The centrality of the ECHR is like clearly part of that.
The Northern Ireland cases have not all been about the Troubles, and the convention has been utilised here on a lot of what I'll call social justice issues. Social justice questions still form a lot of our jurisprudence and have invoked the convention. And there are a number of other cases that I think are quite seminal where our own devolved assembly did not determine certain issues, which are difficult social policy issues, at a time when the assembly was not sitting, and the courts had to look at those. These are cases that involve, for instance, abortion in Northern Ireland and same-sex marriage, and invoke convention principles to really get to a point, I think, in parallel, where there were legislative developments, either in the devolved assembly or in Westminster, achieving a result on the basis of rights arguments. The arguments that we get in the courts today continue to be invoking Article 2 of the Convention that I've spoken about, Article 8 of the Convention, Article 6, which is the right to fair trial, along with Article 14, the non-discrimination provisions. Very briefly, I would say we also have a further body of case law, which is post-Brexit, which is in relation to application of the Windsor Framework and how that interacts with EU law and human rights-based claims. This is a very complicated area, but in a nutshell, what we are facing are arguments that post-Brexit there has been alleged a diminution of certain rights, and so that is prohibited by Article 2 of the Windsor Framework, and so the law should not apply. Whether or not this works in legal terms depends on whether the rights are underpinned by EU law. We have grappled with a number of these cases which arise in the Troubles area and have arisen in the area of immigration. Looking ahead, well, I'm going to mention two areas. They're both related to the changing world we live in. And I think the parallel with that is that the convention has always been described as a living instrument. So it has to adapt to changing times. Two issues are live at the minute, which have international reach. So they are pertinent issues domestically within Europe and worldwide. And the first is climate change. We have had a number of cases in Northern Ireland on this issue. They have largely been framed from a constitutional perspective, which by that I mean the argument has been raised that the Assembly has not fully complied with the obligations set out in our Climate Change Act. And we're not alone in having those cases. They're appearing in the other parts of the UK as well. And I expect in the Republic of Ireland on a constitutional basis. But allied to the constitutional argument, there are rights-based arguments, usually. So the arguments raise that there's a positive obligation to protect people from the effects of climate change on their health, well-being, quality of life. So that's going to be something that I think is the future of convention-based arguments. The other area that I will briefly mention in terms of the future is AI. AI is a vast topic. The Council of Europe have had to look at this because of the effect on the member states and broader. So the legal framework that the Council of Europe have looked at tries to give a template for states to deal with AI. There is the EU AI Act as well, which is an act that isn't part of our domestic law in the UK, but nonetheless, I think hits the themes that are going to be the challenges from AI: privacy, non-discrimination, transparency. In terms of harmful content on the internet, it's a massive area that I expect we will have more jurisprudence on. The other areas, of course, Article 10 and freedom of expression, and that will attract a debate about the role of AI and how that can interplay with Article 10 of the Convention. So those two areas are extremely important to keep an eye on. The overarching issue, of course, and I just come back to what the Convention means to us in Northern Ireland and elsewhere in terms of stabilising the political consensus post-war that there was into an instrument to protect human rights. And that's part of the rule of law as well. The rule of law is an organising concept that we talk about a lot in legal circles. It remains something to remember and is the barometer of our times that we should not lose sight of. So notwithstanding all of the technological change that we have, and some of this, I should say, is really good. It should be a compliment to our legal system. We do have to come back to making sure that we are governed and we apply the law to achieve public confidence in law and to really embed the fundamental principles that are found both at our common law and in the European Convention on Human Rights.
Miss Justice Unani Rafferty, Judge of the European Court of Human Rights.
René Cassin, the spiritual father of the Convention, went on to become the President of the European Court of Human Rights in 1965. On the occasion of his receiving the Nobel Prize in 1968, he said, "There will be no peace on this planet as long as human rights are being violated in any part of the world." Fundamentally, the ECHR is a project designed to promote human rights and thereby to promote peace in Europe. Ireland has played and continues to play an important role in this European peace project.
You have been listening to the European Court of Human Rights, an Irish perspective, a curious broadcast production for the European Court of Human Rights. Original music score by Conor Lennon, narrated by Rory Lonergan. Thank you to our contributors, Mr. Justice Brian Murray, Lady Chief Justice of Northern Ireland Siobhan Keegan, Professor Fionnuala Ní Éileán, Anna Austin, Jurisconsult at the European Court of Human Rights, and John Darcy, Deputy to the Registrar, Grand Chamber of the European Court of Human Rights, and Daniel Holder, Director of the Committee for the Administration of Justice. Special thanks to the Department of Foreign Affairs and Trade and the podcast project team, which includes Miss Justice Unani Rafferty and Mr. Justice Brian Murray.